Good day everyone, I am Severkin Makaran and I will be the one who will discuss to you about what is rights. So rights are the legal, social, or ethical principles of freedom or entitlement. It is also the fundamental normative rules about what is allowed of people. Rights also are of essential importance in such discipline as law and ethics. So moralists said that there are four elements of rights, namely the subject, the object, the title, and term. So let's begin with subject right. So subject right is a person that refers who is vested with the moral power to do, to hold, or to exact something as his own. So the second element of rights is the object of a right. It refers to the right to which a person has a right. Actually, there are three kinds of object of right. The first is the right to commit or omit. The second right is to keep or hold something. And the third is the right to demand something from others. The third element of right is the title of a right. It refers to the right basis of right demand by the person who has the capacity to exercise such as right. And the last is the term of right. It refers to the person whom found the corresponding duty to right. So next is the source of right. Right originates from the law, particularly from the natural law and human positive laws, civil and ecclesiastical. Since the source of the right is the law, therefore we can only speak of right in the context of the law. So next is the kinds of rights. We can speak of 10 kinds of rights, namely the natural, acquired, public, private, positive, negative, alienable, inalienable, perfect, and imperfect. So let's start with the natural rights. Natural rights are those which man acquired by birth. These rights also called human natural rights or human rights. For example, the right to life, to freedom, to educate, and to livelihood. And there are many more that involves our personal rights. And the second is acquired rights, are those which man gains through the fulfillment of some conditions. For example, a citizen or a person to vote, or technically called suffrage. The third is public rights, are those rights which are possessed by a perfect society. For example, church and state. And fourth is private rights, refers to which are possessed by an individual or by an imperfect society. For example, business enterprise or an organization. And fifth is positive rights, refers to which confer upon a person the power to do certain things. For example, right to marry, right to possess wealth, among others. And sixth, negative rights, refers to which do not confer upon a person who has the right to perform certain things. For example, the right to steal, to kill, the right to commit immoral acts, and the like. Seventh, alienable rights, when can be renounced and transferred. For example, right of ownership of a piece of land, building, or vehicles, or money. And eighth, inalienable rights, refers to those rights which cannot be transferred or renounced, since they are indispensable for a person's basic obligation. For example, right to life, right to adore God, and the like. Ninth, perfect right, which are enforced by law. This is why perfect rights are also called legal or juridical rights. For example, rights of parents to support their children, rights to demand payment of a certain debt, among others. Lastly, the imperfect right. This is the reverse version of perfect rights, which are not enforced by law, also called non-juridical rights. For example, the one rights to express gratitude to a benefactor. So we will be moved on properties of rights. There are three properties of rights, which are the right of limitation, collision, and inviolability. So first, the limitation. Limitation of right should be properly observed, otherwise the right of others are violated. The second, the collision. The collision of rights when two rights are in conflict. Nevertheless, if there seems to be a collision of the rights, the greater rights should prevail over the lesser one. And lastly, the inviolability. The rights of intrinsically inviolable. Thus, if the rights of certain person is violated, the person can use physical force in defense on it or in enforcing it. We must free ourselves of the hope that the sea will ever rest. We must learn to sail in high winds. Happy sailing, everyone.
A pleasant afternoon to each and everyone. I am Lotibel M. Lubguban. Welcome aboard, everyone. Please make yourself comfortable and kindly listen as I discuss the chapter 2 entitled Duties. A. Meaning of duty. Viewed objectively, duty means anything that ought to be done or omitted. Subjectively, duty means the moral obligation of a person, or inasmuch as only human person can assume duties because only human persons are endowed with freedom to respect the right of others. As a moral obligation, duty binds the will or it is laid on the will since just like relative. Right duty originates from law. B. Kinds of duty. Generally, there are 6 kinds of duty. There are natural, positive, affirmative, negative, perfect, and imperfect. Natural duty is one which is imposed by the natural law. For example, the duty to worship God or the duty to preserve one's life. Positive duty is one which comes from positive law. For example, the duty to hear mass on holidays or on Sundays, the duty to pay tuition fees or the duty to pay taxes. Affirmative duty refers to the moral obligation of a person to do an act. For example, do good, avoid evil, give alms to the needy. Negative duty refers to the moral obligation of a person to avoid or omit something. For example, do not steal, do not lie, do not kill. Perfect justice. Pay just duty for salaries. For example, is one or which wages the duty obliges to the one employee's employer or workers. Perfect duty is also called juridical duty. Imperfect person from duty is standpoint one which does justice, not obligate but from the standpoint of charity or other virtues. For example, giving donations to the indigents or victims of natural calamities. C. Exemption from duty. The following are the principles that govern exemption from duty. 1. Common necessity never exempts one from duty. 2. No necessity exempts one from a negative natural duty. 3. Extreme or grave necessity exempts one from affirmative natural duty, provided there is no involved violation of negative natural law. And lastly, extreme or grave necessity exempts one from the injunction of positive law as long as there is no involved violation of negative natural law. Life is like the ocean. Waves will try to knock you down and push you back to where you started, but once you fight through them, the entire ocean is yours. Happy sailing, everyone!
Good day, everyone. I am John Joshua Malikay, and for today's video, I am discussing the chapter 3 titled Justice and Morality. A. Meaning of justice. Justice means the habit that enables one to give every human person his due or his own right. In our previous discussion of right, we understood that the right entails of relation since right is correlatively of duty. Likewise, justice also denotes a relation. One can give each human person his due only in the context of relation. Thus, justice is realizable only in the context of man's existence with his fellow man. In this light, we can only say that there is justice in the Philippines if there is milieu of giving every Filipino his due or his right as a citizen of the Republic of the Philippines as a human person. Next is B, the kinds of justice. So based on the foregoing schema, we can say that in a broad spectrum, there are two kinds of justice, namely general legal justice and particular justice. Let's discuss first the general legal justice. So when we say general legal justice, it is one by which a human person wishes and does what is right in relation to the common good. This kind of justice is akin to laws since primary laws are not for the good of individuals but for the good of the whole community. So under the general legal justice is equity and common legal justice. When we say equity, it is a kind of general legal justice by which a human person judges well and does what is right to others, not necessarily from injection of the moral laws, but from the civil law first. And when we say common legal justice, it is one by which a human person is inclined to will and do what is for the common good of others in accordance with the moral law or in accordance with the prescription of civil law. Next is particular justice. So when we say particular justice, it is one by which a human person wishes and does what is right in relation to another person who is accounted as an individual inherent right to his own private good. Particular justice, therefore, is justice between persons. So under the particular justice is commutative justice and distributive justice. When we say particular justice, it is one which deals with fairness of exchange. This kind of justice exists in the relationship between individual human persons or between entities like nations or corporations. And when we say distributive justice, it is one by which a human person wills to apportion or share the goods which belong to a community or to individual human persons who are part of his community. In other words, distributive justice is sharing of the wealth of nation, including natural resources and food within the ingredients and the disadvantaged. So let's proceed to see on Philippine criminal justice system using Caputo's concept of repetition. So the pace of the movement of the criminal justice system in the Philippines revolves around the four elements that are intrinsically involved in the prosecution of cases. These elements are follows: 1. Accused, 2. Lawyer, 3. Law enforcers, and 4. Judges. Let's discuss the number 1, which is accused. So under the law, the accused is a person who is charged with an offense, be it a crime, a felony, or an infraction of law. The revised penal code of the Philippines classifies the accused as follows. First is principals, those who take a direct part in the execution of the act, those who induce others to commit it, and those who cooperate in the commission of the offense by another act without which it would not have been accomplished. Next is accompliances, persons who are not being included in act, operate in the execution of the offense by previous or simultaneous act. And next is accessories, those who having knowledge of the commission of the crime and without having participated. So let's proceed to the second element, which is the lawyer. Under the provision of rules in the Code of Ethics, Legal Ethics, Among lawyers, lawyers are members of the bar. They are persons who are imbued with virtues becoming of a man of law. As a member of the bar, a lawyer is entrusted with lofty, broad, and sacred and mission that is his extensive knowledge of the science of law and a deep sense of justice anchored in a personality which is glittered by his solid moral integrity. As a man of law, he is necessarily a leader of the community and being looked up as a model citizen. So next element is law enforcers. This uniformed person comprise the members of the Philippine National Police or the PNP, the members and agents of National Bureau of Investigation or NBI, and other component bodies and agencies whose task is to implement the law. By virtue of their status, they are not members of the armed forces of the Philippines and that technically they are not according to the revised penal code of Philippines. Them persons in authority but rather duty considered as agents of persons in authority. Example of this are legislators from national to local levels, judges, lawyers as they dispense their functions as partners of courts in administration of justice, and teachers as they execute their functions in their auspice of their respective workplace. And the last element is the judges. According to the Philippine Daily Inquirer, dated August 22, prevalence of graft had given rise to the perception that for the right price, some judges would deliberately misinterpret the law. In the Philippine Star editorial, August 21, 2002 issue, the newspaper cried aloud its cynical remarks. You can see why any campaign against corruption ends up nowhere in this country. We all know that many government workers are corrupt and inept, but attempts to disrupt business as usual in any government agency. Let's proceed to the constructive critic. In the Philippine justice system, offenses that are deemed criminal shall be prosecuted as follows. First is the filing of the complaint by aggrieved party. Second is primarily investigation. Third is the filing of the information before the court. Fourth is arrest. Fifth is bail. Sixth is arrangement of plea. Seventh is motion to squash. Eighth is pre-trial. Ninth is trial. 10th is judgment, 11th is new trial reconsideration, and 12th is appeal. Let's discuss the next topic, which is Caputo's concept of reputation in relation to Philippine criminal justice system. So, reputation and the flock. John Caputo, in his radical hermeneutics, explains that reputation is a creative production which pushes ahead, which produces as it repeats, which produces what it repeats, which makes a life for itself in the midst of difficulties of the flux. Reputation means the task is set for the individual to preserve in time, to stay with the flux, to produce his identity as an effect, and this ultimately is a religious task. Next is conclusion. The first conclusion is purgation from among members of the law enforcement forces, ranging from the members of the Philippine National Police up to the agents of National Bureau of Investigation and other law enforcement bodies and agencies. Second is debarment of conviction of dishonest, immoral, and corrupt members of the bar. Third is stiffer punitive measures for the corrupt, inept, and the ignorant justice. This sanction may be crafted in a form of dismissal, imprisonment, and forfeiture of benefits, among others. Fourth is legal, use of the letter of law or resort to rule of law, and substantive use of the spirit of the law means in interpreting the law in application to judicial decision. This requires judges to bracket their biases and prejudices in drafting judicial decision. And last is the use of DNA testing not only in due prosecution of criminal offenses but also in post-conviction instances to convict whose guilt beyond reasonable doubt is not justifiably proven. This could assail unjust or prejudicial conviction of innocent convict. This would result through valid and objective legal justice to the accused. And that would be all. Thank you for listening. Sail away from the safe harbor. Catch trade winds in your sails. Explore, dream, discover. Happy sailing, everyone.